My name's Al Kreischer. I think I've met virtually everyone in here. About 2 weeks ago, I had a conversation with Sarah, and I thought it might be worthwhile to discuss title insurance and its role in the closing. I've found over the 30-some years I've been practicing, very few people understand title insurance, title commitments. I see where even sophisticated buyers get their title commitment delivered to them. They put it in the file and then check it off their list that the title insurance is done. But no one ever reviews the title insurance to see what it contains. Title insurance is unlike other insurance. Title insurance ensures the title to the property, that it's free and clear of all liens and encumbrances, and there's nothing of record that would infect its marketability, that is, ability to convey good title to someone. When you have your contract, and this is particularly important if you're the buyer, when you have the contract, there's a provision that allows for title insurance and a survey. They usually go hand in hand. When I represent a buyer, there are three things I focus on: the due diligence provisions, the title insurance provisions, and the survey provisions. Because if those are satisfied and acceptable to you, you shouldn't have any problem with the property in subsequently selling it. When we serve as the closing agent, we get the contract, and it shows us who the buyer and seller is. It gives us a legal description, and it usually has a time frame for us to do the title work and produce a title commitment. Now, in order to do the title commitment, we have to perform a marketable search of 30 years or more. You have to go back in the record more than 30 years and find out who owned it at some point in time, and then you go forward from one party to the next in the chain of title. And you have to check that each party properly conveyed it to the next, that the time they conveyed it, there were no liens, or the liens were satisfied and discharged. There were no judgments or any other adverse matters that would affect the title at your closing. Sometimes people will give us a contract and say, it's a cash deal, can you close it tomorrow? Well, if there were no title insurance, that wouldn't be a problem. If there is, it sometimes takes some time to do a 30-year marketable record search. When I first started doing this many years ago, we didn't have computers to do title work. So every morning, I would drive to the courthouse about 8 o'clock, and I would go through the public records, do my 30-year search with my pad and pencil in hand. And I'd come back to the office, and we would produce a commitment. Now you can go online and do that, and it's so much easier. It's remarkable. About 91, or I guess maybe 89 or 91, I got a computer in my office that actually did the search for me. I would just put in a legal description. You didn't even have to put the parties in, and it produced a search. But in any event, sometimes the search, you need to understand, takes some time. I do some work for the county, and some of their searches might take 3 or 4 days to do because they're usually convoluted. But in any event, what it ends up with is a title search that results in a commitment. I've made a copy, and I'll pass them out, of the standard title commitment. And I have a few of these if you can pass them out to. I'll just go through the parts so you can understand what they show. The fact that you get a title commitment does not mean you have good or marketable title. And the purpose of the commitment, if you go to the first page, if you can find it, actually it looks like this, folks. I think it's the third page. And you'll see at the top it says Schedule A. And it's got a number of paragraphs after that. Schedule A really just shows you the transaction. The first thing, paragraph 1, is the effective date. That's the date through which our search was performed. So when we perform a search from, say, 1965 through last Thursday, we'll put the date of the ending date of that search as the effective date. Once we issue the commitment, closing may occur immediately after that. It may be a month or 2 months after that. So we have to do a supplemental search to make sure nothing is falling in the public records during that period of time. And then underneath that, it shows who the proposed insured is. That's the buyer. So that should identify the same, it should be the same person as in your contract. And across from that, it shows the purchase price or the insured amount. So this buyer is being insured in this transaction for $605,000. Underneath that is the loan. It shows who the lender is and the loan amount. This one, there seems to be reversed, but the difference is this is an SBA loan. It has some working capital in it and some other provisions. So in this case, the loan amount happens to exceed the purchase price. Then paragraph 3 shows that they own fee simple title. And then paragraph 4 shows who actually owns the property. That should be your seller. Paragraph 5 needs to correspond with the property description in your contract. Now, when you have real estate in Florida, there's really 3 types of legal description. This one is probably what you're most familiar with. This is a lot and block within a platted subdivision. So you have lot, block, Tampa Palm subdivision, according to the map or plat, according to plat book and page, Hillsborough County. That's kind of simple because you go to the public records and pull the plat and see your platted lot, the road frontage, what's surrounding it, what's behind it. Could be waterfront, could be wetlands area, a variety of things. If you're building a house, you need to look at some setback lines for wetlands and easements, utilities. But that's a simple plat. When you buy property, sometimes you buy raw property that's not been platted yet. That can be described as meets and bounds. We have calls, you have a point of beginning, then you're running west a certain distance, and then south and so forth. That's meets and bounds. Then the other one is the government survey. 150 or more years ago, they did a grid across the state, across the country, and it shows the section, township, and range. And that's another form of legal. But if you're buying raw land that's not been platted, it's either going to be meets and bounds or it's going to be a government survey. You really don't need to understand that much, but the thing that you need to do when you get your commitment is provide it to your surveyor before he does the survey, because he'll use this in preparing the survey and platting everything that's shown on here on your survey. Now, if you go to page 2, page 2 is what's referred to as Schedule 1 requirements. Whenever you handle a transaction as the closing agent or the attorney, there's certain things you need to do in order to ensure the title. Obviously, you need to prepare a deed, have it executed and recorded from the seller to the buyer. That's the obvious one. You also have to, if it's a mortgage on the property, have a mortgage signed and recorded. So it sets forth all these things. This one I pulled out because there's some unusual things on here. This is why it's so important to look at this. In this case, we have the satisfaction of mortgage, but there's also an assignment of rents, a variety of things incident to that loan that need to be satisfied or released. But if you go towards the bottom as well, I think number 14 is a judgment. So there's a judgment against the owner that needs to be released or satisfied. I think 13 is a federal tax lien against the seller that needs to be satisfied. So if you were to get this title commitment, you need to understand that, make sure they are obtained by the closing agent at closing. What I customarily do is I ask the closing agent if they would, at or before closing, mark up their Schedule B, 1, the requirements. Just say the requirements. Ask that all of them be marked as satisfied at closing. So you're assured that when the policy is issued, all of these things have been removed. If for some reason they can't get satisfaction or release of the tax lien, that's a bit of a problem for you. So I always get that. Everything should be satisfied and removed from Schedule B, 1. Schedule B, 2 is what's referred to as your exceptions. Title insurance does not insure everything. There are certain things that are excluded. This is particularly important for the surveyor because he will go through each item, and if they affect the property, he'll show the item on the survey where it is, and you can then look at that to see if it in some manner impairs your use of the property. You might have some type of easement running through the property, favoring another neighbor, which may run through the middle of it and impair your use. If you find you won't be able to plat it without relocation of the easement or release of the easement. They're very important to go through these things. If you look at this, you'll see number 1. Number 1 is what's referred to as the gap clause. When you do your title search, you'll remember the effective date on the first page is the date your search ran through. Between that date and the date of recording is what's referred to as the gap. Things can get recorded in the gap, and we had that issue on one of those cases a few years ago, where something got recorded early one morning, a judgment that fell in the gap, and the title company kind of disregarded it, and we had a big issue. But in any event, The gap clause by statute should be removed, because when you go leave that closing table, it's not your problem if something gets recorded after that closing. That's the agent's responsibility to make sure it gets recorded promptly to avoid any gap issues. What's happened recently in Hillsborough County, we have a system in our office where we can scan our closing documents directly to the clerk. So when we walk out of a closing, we go to the back and we stick the deed, the mortgage, notice of commencement, whatever it may be, in the scanner, and immediately it scans it and sends it to the clerk's office. We have an account set up where it takes the documentary stamps out of our account and pays for them. We can have someone actually sitting at the table and hand them the recorded deed before they leave. It virtually eliminates many of the gap issues you may have. But the gap is one issue. I always ask at the closing that they delete that. If you look at number 3, that's called your standard exceptions. Every title commitment has certain things it does not cover. Parties in possession. So if you have a tenant in the property, that's your problem. Unpaid liens for mechanics liens. So if there's construction or repairs or improvements, it doesn't cover that. Survey matters. If there's some boundary line dispute, it doesn't cover that. I had a client many years ago come to me and he said, I bought property in Dade City and I was told by the seller it was lakefront property. And he says, I found out my neighbor sold his property and the new owner came to me and said, you have no lakefront access. And so he came to me and he said, would you present a claim to the title company because they insured the property? And I said, let me see your survey. And he didn't get one. I said, well, you don't have a survey. The title commitment does not insure against those type of issues because there's an exception that says if there's a matter survey that a survey would reflect, they don't have any coverage. To overcome these things, there's certain things that happen at most closings. You always have an affidavit that's signed by the owner saying that they're in possession and that if any work was done within the last 90 days, it's fully paid for. And you can then remove the parties in possession and the mechanics liens issues. So those things are deleted. If you get a survey at closing and present it to a closing agent, they will remove the survey exception. So that broadens your coverage for any survey matter. And survey matters could be a boundary line dispute, could be a misunderstanding of where your boundary line is, it could be an overlap in boundary lines, could have an access issue too. So it's very important to get your standard exceptions deleted. You can only do that by either getting a new survey and an affidavit, or if the seller has a survey and the improvements on the survey have not changed, you can use that survey. Surveyors don't like you to do that because it costs them a few bucks. But this is important to do. And then when I go to a closing, I always say, get rid of the gap clause and the standard exceptions.